then you can raise the issue about it being void.
Yeah, I mean, and there's plenty of precedent for that. If you're going to attack a case that happened long ago, and then the door of the case closed, if you're going to attack that, you've got to have, you know, lack of jurisdiction, unconstitutionality, something else about it. So yeah, you are correct, but that's the avenue you have to go here to find that.
So there's a lot of, I think this goes to, and because we're going to switch gears in a second, but this goes to exactly why we need an association. I'm going to back Brian and Adam's purpose here, because I see elements of these arguments are coming across my desk from different attorneys. We don't have a way that this conversation, I mean, we've won a couple of the standing arguments in the appeals court, but I don't know that folks who are doing the summary process cases have those decisions, right? We're not sharing the best arguments that are evolving, because we don't have a way for everybody to be seeing what's happening. And I think we have a huge steep climb to get the courts to recognize any one of these. But what I've learned from watching the work that you're all doing and coalescing the work as much as I can in the work that I'm doing is that almost everything we're arguing, we're right about. And because the laws, to some successful extent, are a single fabric, there are usually 5 to 6 ways to get in on any one of these, all of which are true. Because the law purposefully is the term I keep using is multiply determined. It's wrong. If it's wrong, it's because it violated 10 laws, not 1. And you can, or 10 procedural things, or 10 constitutional, whatever elements they are. Every one of those is a valid way in. The problem is we're not getting traction from the courts necessarily on those arguments. And so, you know, I think we would do well to have all 10 of them for each thing, so that when you're in front of a particular judge, you can go, oh, this is a kind of judge who's going to get real property law. This is a kind of judge who's going to get the jurisdictional argument. Whatever, because they're multiply determined, we're right. And how do we know we're right? Because no matter which way you turn, the law is with us. And somehow we've got to get the judges to listen.
I think you're touched upon that. The bigger attack, I mean, like I've been doing this since 2007. The broader picture is, at some point, you have to employ strategy. And although you know you want it to be here, if the situation in our society and the courts are still over here, you have to work a little bit with where they are. And you know, I use the proverbial baseball card. You keep a baseball card on each court, on each judge, and you know what works and what's working. And so. And you don't want to bombard them with too much, because then they're not getting it. So these are, you have all of your information in this horribly long complaint that's scary, but when you go into court, you go to argue a motion or something, you pick like the top 3 or 5 best arguments and go with that. Yeah.
So he's on the same page we are. Well, Sarah and I have been trying to get enough resources to create a cheat sheet on each judge, because what we know in Worcester is that when we had the same judge, 2 judges for a long time, we got to know, we're getting a breakthrough. This judge, has just asked for were you on that? I can't remember who it was. We had a judge that had just said that she wanted to look at the trust argument. And yeah, housing court in Worcester. And, we were like, oh my God, that's great. But the lawyers hadn't heard it. Our pro se folks had heard it. And we need a way to feed it into a data bank, so that if you're the next lawyer arguing in front of that judge, you know what the judge said they were interested in.
The Mass Law Reform used to keep a judge, well, Tony Windsor, but I don't know if they still have it.
Rest in peace.
Yeah,
yes.
Exactly.
Without Tony, many things don't happen.
You know if anyone kept that up?
No, we don't have one for the foreclosure stuff. I can tell you right now.
They should do that.
We need it.
Well,
It's not that many judges. It's a lot, but it's not impossible.
It's hard because of the cuts in legal services.
Yeah.
Even the housing people at Mass Law Firm are working part-time.
Oh, really?
So I'm going to
Yeah.
overall facilitator action of privilege here. We're supposed to be done with this section. We need to move on to Senate 2015. And so I'm going to drag us away from land law for a while. I don't know that we're going to.
we're not going very
far from land law. In fact, maybe I'll leave this up here. So I'm going to say a little bit. I think you're going to say a little bit. Adam,
Yeah, let me just step out real quick.
And then Sarah's going to say a chunk. And I don't know where here are my stacks of documents. Here we are. You want to take one and pass? All right. Senate 2015. I agreed to do a quick overview, nope, that didn't work, on what this bill actually said. I'm not going to try not to editorialize. I'm just trying to say what the bill actually says. So this legislation is legislation that we spent 5 years fighting, and I think we get credit for defeating the richest industry in the world for 5 years.
Yeah.
Yes.
Thank you. So the industry filed this bill right after the Ibanez decision, and in their most recent, they finally this last round had to produce a fact sheet on the law. Up until you know this.
The ever-changing law.
Move away from.
The ever-changing file.
And this round, I think because they really wanted to try and get it passed, and we defeated them so profoundly in the summer of 2014, they actually finally produced a fact sheet. Now when you're lobbying, I'm a lobbyist for our movement, so I'm now wearing my lobbyist hat. Normally when you're trying to pass a piece of legislation, you produce a fact sheet, and that tells the legislators what they're passing, and the industry had never done it. And in July of 2015, they finally produced a fact sheet. And people who want the fact sheet, it's very revealing. They didn't hide a thing. And what they say in the fact sheet is, the reason we're passing this law is because the SJC screwed up title in our state. They didn't use the word screwed, but they used some synonym. And the way they messed it up was through the Ibanez decision, the Ibanez, Bevilacqua, Eaton, that should be five. Oh, no. Ibanez, Bevilacqua, Eaton, and Pinty. The Pinty paragraphs just erased in there, and they just come down in their fact sheet. And then they misquote headings. And what they say the purpose of the law is to reverse the SJC decisions. That's what they're asking the legislature to do, in so many words. So what this legislation says is, if there's an auction and there's a third-party purchaser, and the homeowner does not manage to have a challenge in court to that foreclosure, and get a certified copy of their pleading. This was added after the legislators were reading and knew what they were voting on. This was added as compromise language. It was not compromise language, and the legislative leaders who went along with the whole thing are on our side are really pissed. But you need a certified copy of your pleading, and you need it recorded at the registry. And if you were previously foreclosed, you have 1 year, and more recent foreclosures, it's 3 years from the recording of the foreclosure deed. As long as the homeowner doesn't do this, then this third-party purchaser has title, free and clear, forever. And you're still allowed, but it's under 93A, as the homeowner, to go after whoever lied in the foreclosure affidavit that was attached to the foreclosure deed for damages, right? Because title's gone. So that's sort of the logic of what they're saying. And there are lots of little specifics here that are very important. So the third-party purchaser definition is really important. The industry said that they were, and I think the language of the actual language of the law is in one of these piles. This looks promising. It says Senate 2015 on the top. So if you take one from the top and one from the bottom and pass. All right. So the third-party purchaser ain't just any third-party purchaser. The third-party purchaser has to be, the industry's logic was, we're not going to let the banks off the hook for illegally foreclosing. So the third-party purchaser cannot have any relationship of any kind to anybody who might have had a hand in the whole mortgage foreclosure process. And so it says that, among other things, you can't be an investor or a guarantor of the whoever had the mortgage or the foreclosing entity. So just to clarify, who are the guarantors of Fannie and Freddie mortgages?
We are
We are. The taxpayers are.
taxpayer.
So you couldn't be a third-party purchaser under this law if the mortgage was held by Fannie and Freddie, which most of the time we don't know unless they come out after the foreclosure and tell us, if you are a taxpayer. So we think that third-party purchasers are going to need to put in that they're tax resistors to be a third-party purchaser where there was a Fannie or Freddie mortgage. And third-party purchasers can't be investors. That's presumably going after the securitized trusts. Anybody in this room part of an association that invests in the stock exchange? Anybody got a pension that they're being paid by? Anybody have an investment firm that does your investing for you? And how would a title examiner know whether you as the third-party purchaser had any such investments? So in their attempt to guarantee that there was no relationship to anybody that might have been the actual mortgagee or the foreclosing entity, we think they may have wiped out pretty much every third-party purchaser. They also said, in terms of the foreclosure affidavit, which this all hangs on, it is the validity of the foreclosure affidavit that guarantees this title to the third-party purchaser. The foreclosure affidavit, 244-15 affidavit, has typically been filed in the statutory form. For folks who are the pro se folks, this is the affidavit that you see when you get your foreclosure deed out, and attached to it is an affidavit. And that affidavit, the statutory language under Chapter 244-15 says that they have to enumerate the acts they took to foreclose particularly. But at some point, and I can't remember when the statutory form of the affidavit came in, but it was maybe 120 years ago, Sarah, does that sound right? I think so.
Around for a long time.
Something like that, maybe closer to 200 years. No, 120, it's 1910. So the statutory form is very short, and that's what you're all used to seeing. It says you were in default, there were notifications in the paper, you were sent a notice, and what happened at the auction. And ta-da, we did everything legally. That's what the standard foreclosure affidavit says today. In the 5 years of fighting this legislation, they used the term that it was the statutory form of the foreclosure affidavit that this bill hung on. In the final throes, the House version removed the language saying it was the statutory form and went back to the full-length language of the statute itself. And so the one thing we absolutely managed to do was to go to our Senate friends and say to them, they removed reference to the statutory version, statutory form, abbreviated version of the affidavit, and they've now hung the law on the full-length affidavit in the House. Please accept that as friendly language when it comes back to the Senate, which they did. So this law depends upon a full-length foreclosure affidavit to even be applied.
Does anybody do that?
No. No, that's why we went to our friends and said, please keep that language out. And for anybody who's been watching the SJC try and interpret stuff, they've been saying if in the legislative history there's some clear choice made by the legislature. So we have the language of the abbreviated statutory form in the first 4.5 years of this piece of legislation, and then right before it passes, it becomes the full-length affidavit.
But
So-
where, as I'm reading it, because I have the before and after right here, the language is the same. The language is the same about the affidavit that was required before as it is after. Am I missing something?
You don't have you don't have old enough language.
It's changed a lot.
No, because I'm talking about
I call this the final version law that keeps changing. So I don't even know if we're all on the same page because it keeps changing. I don't even know what it says today.
Hendrick says that the basic affidavit of sale is sufficient.
I know what it said yesterday.
Right,
So
no,
what's changed about that?
In July, the version that passed the Senate in July
Yeah.
said statutory form. The version that passed the House in October? Yes, October 8th, said, removed the reference to 183 Section 8 or whatever the statutory form is, and just referred to 244.15. And that section then carried through until what was enacted.
I'm not even sure I even have a copy. The copies for you?
There was copies coming of two things, Senate for 2015 and the parchment copy. And the parchment copy is what was signed. It's also not what was enacted, but that's okay. No, it's not, but it's what it is. I think that I've gone through the key things that you have to watch out for is the third-party purchaser and what the foreclosure affidavit requires. And there's a lot more to say about this, but that's what the raw language of the bill says. What we're most concerned about is this idea the title is going to vest in a party that has the Brooklyn Bridge. Right? Because we've all seen foreclosures that have gone, have been considered valid by the courts where there was no notification, where the party was not in default, where obviously tons where the mortgagee was not the mortgagee, violations of the mortgage that now everybody agrees are violations of the mortgage. Essentially, as far as we can tell, the way this is written, if it's interpreted the most draconian it could, you no longer have the protections of the mortgage, the protections of the foreclosure process itself, the protections of the note that still is viable, or any of the things related to whether you're in default or any of that stuff. It's all gone. If they can file a foreclosure deed with a passable affidavit, someone purchases and you don't know, your title is gone. So that's our biggest problem.
Can I ask a question too? Post-passage, which is pretty recent, what had the title? How does it change what the title insurers say about what's acceptable for? Except we don't know. Is it too?
No, they have. They've published and they've done some workshops on it. But all they're saying is just hang in there and you're fine. To the title insurers, talking to the industry, just as long as you can get past the 1 year or 3 years, you're there.
So it means there's going to be no exceptions in the title insurance policies?
There are exceptions now. I don't know if they're going to remove them.
That's the question for the insurers.
Yeah.
No, that's what I'm trying to figure out.
Adam, you were going to talk about that, the 183.5B way to protect people, or?
Yeah, I mean, right now, I called Land Corp the other day, and I also spoke to an attorney I know that worked for Orleans, who's working at one of the courts now, just to get their opinions on that. He thinks that just getting a copy of the complaint and get a copy of the law requires that a copy of your complaint challenging the foreclosure, if it's a civil action, or if you're in housing court or district court in a summary process, that your answer, or your counterclaim, or whatever showing that you're challenging it, that alone, just getting that recorded, is enough to satisfy the law. The registry, I don't think they've gotten enough of these yet, so we don't really know. I don't know if they're really.
Actually, we've had experience doing exactly this in Worcester several times, so we can tell on the ground. But
Yeah.
you want to just explain to people what a 183.5B affidavit is?
Yeah, it's a law that allows an attorney has to certify it. It says that if the affidavit helps the chain of title. It's a pretty broad definition, but if the affidavit relates to the chain of title, the registry should accept it. It has to be signed by an attorney, notarized. I can send a copy to anyone. I use it for foreclosure by entry. I use it for all cases of the foreclosure entry. I use it to challenge that entry, which no one, Longoria has challenged me on it once, but for the most part, everyone kind of backs away on it. It's also, 183(5)B affidavit also is good for recording like a summary process decision as a way of clouding the title. There are a lot of ways you can use it. But for this case, like my preference would be instead of simply just a pro se party recording a complaint or an answer, I think it'd be better to do a 183(5)B affidavit with the attorney stating this is a true and accurate copy. This is done to challenge the validity of the foreclosure and recording it as such. I just think it would be a stronger than just having a random complaint.
So we're going to build on that, and our recommendation because that process is a mess, and we'll explain why, is that we think that 183(5)B affidavit, so these are what Adam just said, right? Anybody can file something related to the title. I suspect this originally came around when somebody started building over a property line, and you know, you needed to go on the record that this was not, that they didn't suddenly own the property because they had built over the property line, that people would file these for that purpose. It was sort of to clarify anything related to title. But because the foreclosure affidavits required by this law now must be the long form that no one uses, and the foreclosure affidavit that they're going to try to say to you or to the people you represent, sorry, you missed your 1 year or 3 year, that foreclosure affidavit does not meet the requirements of this law. And so we were thinking that in anybody's case, as long as the foreclosure affidavit is in that abbreviated statutory form, you just file a 183(5)B affidavit saying this law can't apply to me because the affidavit attached to the foreclosure deed is not the long form. And the law is explicitly, so we've actually written some language that I'd like some lawyers to, you know, clean up and make sure it's really tight. But literally addressing the legislative history where they took the statutory form out of the language and only referenced the full length 244-5-15 affidavit, and then anybody can go file it, right? You need a certification from an attorney, but you can apply it to your property as long as you've gone and looked. If anybody finds a full length foreclosure affidavit, please let me know. I've never seen one. They're all the statutory.
I was going to ask, would it be fair to say that just about every foreclosure affidavit that's recorded in Massachusetts is the short
for the last 100 years.
Yeah.
Right, I mean, the Hendricks case that they reference, the original Hendricks SJC case was brought up on whether that short form was sufficient to meet the legal requirements or not, the way it is. And so the court quotes back saying, look, people have been using this for over 100 years, and yeah, it's fine, but only for registering at the registry, not because it's good evidence in court. So they've been pretty clear, and so it's not just recently, it's like for over 100 years. They're all the short form. So you want to go on to constitutionalities there, or do you?
I'm not sure. Talk a little bit about this because I think this is.
People want to know.
Yeah.
Okay.
So originally, what I was going to talk about this was the law, as I mentioned, keeps changing. One of the biggest problems, and there's a few different things about this new law, but one of the biggest problems is it originally was written and even originally published, made part of our body of statutory law in the Commonwealth, had, as Grace indicated, this 1 year cutoff period. And these are significant because this statute applied retroactively to affidavits that have already long been in recordings and registries for many, many years now. There's been a lot of pushback to this law. I myself have spoken to our local senator. I was on a radio station, Dan Wolf.
Oh, good.
I was on a radio station ranting about this. And I know that, Mapple's been active on it. If you go to the website, they have form letters to send out to the Attorney General's office. So I think that this voice was heard rather than having to battle these constitutionality issues in the courts. What I'm seeing currently, and I really use underscore currently because I keep seeing this change, and I've never seen a law go through the legislative process, get approved, end up being published, and then at that point continue to change. So that's what's really bizarre. So currently, if you go to the state website and look for the Mass General laws, and I also check with online Lexis Research, and they have the law that I'm holding in my hands right now. It's much shorter, and this is a part about being organized and having a voice. But as it was originally approved and published, it was essentially the largest transfer of wealth in history because you have like $14 trillion of people's value, just the Massachusetts citizens. We're not talking about a $1 trillion bailout on the federal level that was shared amongst the whole country that everybody was up in arms about. This is $14 trillion, just the state of Massachusetts, saying to Wall Street, you can clear all your books clean by the end of this year because there's no way that 60,000 homeowners are going to get together or have the wherewithal or have the money to file these complaints. There's not even enough attorneys in our state that practice this to administrate that in 1 year. So here's the good news. It's gone now. Will it come back? I don't know. But current law, the 1 year is gone. The statute is the effective date is December 31st, 2015. In my brain, I just call it January 1st, 2016. So starting this year, that's the effective date. It doesn't appear as though they're saying that this is going to apply to affidavits filed prior to December 31st, 2015. We'll wait and see, but so far that's what it's looking like to me in my most recent read. So that's gone, thank goodness. So where is the law saying, as I understand it, currently, the law is saying, first it doesn't apply, as I said, to illegal foreclosures prior to December 31st, 2015. Now, it does have a 3-year deadline it's now imposing going forward. After the 3-year deadline, recourse remains available, as Grace indicated down here, to owners in possession so that means if they're foreclosed on and they are still in their home, they still have possession of the home, and then the bank or somebody at some point has to bring a summary process case against them, then they can still challenge it, even if the 3-year period, the deadline is expired, and that's the 60 days, exactly. So if you have a summary process action brought against you, then you, in either a defense or in a counterclaim to the summary process complaint, where they're trying to get you evicted, they're trying to take your possession of the property, you have 60 days in which to file in the registry a copy of the complaint with your answer, which you're in your answer to either have a counterclaim and or your defense.
I'll just note on that too, the attorney that I spoke with, he thought that just having the first page of the complaint would be enough as like a Liz Penance. I would record the entire thing.
Yeah, we totally disagree with that.
Until there's a clear ruling, the rule is better safe than sorry.
Yeah.
I mean, a true copy attest is something you can just get from the clerk's office, and they stamp it and it'll say true copy attest. Yeah. But as Adam indicated earlier, there's the lawyer's affidavit that maybe could bolster that where needed. I don't even. Does anybody know what are the registries charging for that?
Well, so the W.A.F.T folks have tried this, and Lori's going to help me on this. So one of the things we're trying to figure out is who has standing to challenge this, and so we've been working on different access points for doing something at the SJC about this. So one of the ideas was we don't want to wait a year for folks to say, well, now I'm screwed, because then we're screwed.
Right.
So one idea was that we should get in early and see whether one can get out from under it the way you're supposed to, as opposed to the affidavit that we think is actually a better argument. But we thought, let's try and use the law the way they said it. So this attested copy thing was added after both houses had voted. They thought there was just a compromise version. But the conservative interpretation, which I'm with you on this, Brian, we want to cover our butts as many ways as possible, is that you need a certified copy. A certified copy from the courts costs $2.50 per page. And the registries sound like they've decided as a group, as far as we can tell, that they're going to do the $75 filing fee no matter how many pages it is. as folks probably know, a fair number of the folks who've been foreclosed are way too wiped out to afford $250 a page for a pleading that's, 20 pages long and $75 register. So there have now been 6 people in Worcester
6.
who've tried to get a certified copy and get it recorded at the registry. And one of the folks has a case in federal court that was removed to federal court. Haven't learned your trick yet. Make sure that things don't get removed to federal court. So they were able to get a certified copy off of the federal court system. You don't have to pay for it. You have to pay to print it, but you don't have to pay for certification. It automates. So he had a certified copy. We had folks who'd already tried to get a certified copy from the housing court and record it, and were told that it was too early because it wasn't after December 31st. Of 2015, he's like, it just has to be before the 1-year date. After it doesn't, there's no start point. But anyway, and they were told they were not going to be allowed to use their indigency waiver and get their copy from housing court. So this guy was trying it from federal court, very excited. I don't need an indigency waiver. I can get my certified copy. Went down to the register, and then the register, who before had said it would be fine to just have something certified from the court. Knowing that he had not had to get a clerk to approve it, suddenly said that he needed the judge's approval of the pleading as if it was a lease penance, and but otherwise would let him record it for $75. So then our folks now have gone back to housing court, and we did a very public action. 5 folks, one of whom had a meltdown, 4 people ended up going in front of the clerk to try and get their indigency form recognized. The registries have no way to sliding scale or waiver their fee. There's nothing in statute that allows them to do it. And so our position has been, because this is your right to have access to the courts, that it's the court's responsibility to make sure that you're covered under the indigency statute. So our folks went down with an indigency form filled out so that it was both to waive the cost of the certified copy and to get a fee payment for the registry fee. And as I understand it, you weren't there for the first part either, right? So we're both telling what we've been told happened.
Yes, I was.
You were there at the very beginning?
Yeah.
Oh, you were. So I was told that the clerk initially refused to give people.
Absolutely.
Oh, okay. All right. So.
Were you filming that one?
No.
You can't bring a camera
we
in.
can't. All right, wait. We knew that. So we asked Senator Chandler to come be a witness. And we asked 2 of our reps, only one of whom showed up.
Late.
But we wanted them to be able to tell their colleagues what a piece of you-know-what this supposed little safe haven thing is. So 4 folks went up and were told, no, the court was not going to waive the fee for the certified copy. And I gather that Senator Chandler at that point felt so bad about what was going on that she grabbed the chief clerk and pulled him aside and had some words with him. Apparently, we are told to the effect not only that he needed to properly service people, but also that she wasn't always going to be able to be there, and expected that whatever they did with our folks when she was there is what they would do down the line with folks. So we will see, because we have some folks who held back and will now go test it without a legislator there. And so after that, our folks were told, yes, they would get their fee waived for the certified copies, but that they were not going to and never would, and they had talked to Boston, we don't know what Boston means, about paying for the registry fee to file it. But it's still prohibitive. One of the folks who went said to us while we were headed into the courthouse, she said, somebody should take my $75 that I've got in my pocket, because if they ask me if I've got $75, I do have $75 on me. And we looked at her and said, what do you have $75 in your pocket for? And she said, that's the week's food. You're not supposed to give up your shelter, food, and life's necessities to protect your right to have access to the courts. We told them to keep the $75, but that tells you where people's heads at. They're going to give up their food to try and make sure they can record at the registry. So anyway, what the clerk did say was that they don't cover things like this. That this is just notification to go in the registry, and it's not really about your court case. Note, the fees they will pay include notifications in a newspaper. But we think that if they will pay for notifications in the newspaper, if you're indigent sufficiently and you make the argument, that they certainly should pay for notifications in the registry. So we're going to keep trying. Folks are headed in on Tuesday for an appeal of the clerk's